What is going on, IP family? I am Dave, 10 plus year intellectual property attorney, dealing with everything from copyrights, trademarks, trade secrets, as well as patents. And man, it was a Bloomberg article that I want to share and go through with you guys today regarding OpenAI, who own ChatGPT, their trademark that they now have on OpenAI, and how they ultimately had to get it. They got it through an interesting means, let's just say. And we're going to go through the article and kind of talk about the importance of making sure, really kind of when you're going through the trademark process, you are going about it the right way. And a lot of times you can make sure you go about it the right way just by hiring an attorney. But to the extent that you don't want to hire an attorney, you're definitely going to want to pay attention to this, because this misstep costs one of the, I guess the competitor who has the open.ai domain name from eventually getting a trademark on the OpenAI mark, although he actually had it on a supplemental registrar. Man, we're going to get all into it because this is a crazy story. So before I put it up, please hit that like button for the YouTube algorithm, as well as hit that subscribe button for the IP community. Hit the subscribe button to be a part of the IP community. We talk a little bit about everything, obviously everything intellectual property, hence the name of the channel. But I'm going to give you guys a roadmap. And it's a lot of branches from this road, so you guys have to kind of pay attention. So it was a gentleman, I think Ravine is his name. It's going to come up in the article as I go through it. He secured a domain name for open.ai. And he also was trying to file a trademark. He filed a trademark application to protect the term OpenAI by way of a trademark. Now, we all know that ChatGPT, the company, the well-famous, the well-known company OpenAI, now has a trademark for it. But before they actually got awarded the trademark, another gentleman, Ravine, who I just talked about, he actually filed a trademark application to protect the name OpenAI, and he already had the domain name. And what happened was the USPTO said, hey, man, this is too descriptive, and therefore we're not going to allow you to register it on a principal registrar, which is a main registrar. But we are going to allow you to register it and protect it on a supplemental registrar, which, is not necessarily, again, it's something. And I'm not going to go off into the differences between a principal registrar and a supplemental registrar. I've made previous videos on that. Just know really the big difference is, because you can put the R in a circle, whether it's on a supplemental, your mark is registered on a supplemental registrar as well as a principal registrar. But I would say the biggest difference, or one of the biggest differences, is the fact that when you have a mark on a supplemental registrar, it is not automatically considered distinctive. Whereas when you register your mark, and most trademarks that you see there they are registered on a principal registrar, that's what the USPTO is going to say is a distinctive mark. Now, when you have your mark registered on a supplemental registrar, it's not automatically given that distinctiveness as the marks on the principal. So again, this Ravine character, he had the domain name for OpenAI, as well as he had the mark registered on a supplemental registrar. And much like when you register your trademark, even on a principal registrar, when you register on a supplemental registrar, you have to let the USPTO know that you have to provide a specimen showing them that you're actually using your mark in commerce. And one of the ways he provided his specimen was, say, fraudulent or not up to speed. And again, we're going to get off into it in the article, but his specimen was kind of really misleading, fraudulent, but the USPTO don't know that, so they're accepting that specimen. And kind of when it all came out, once OpenAI and Sam Altman and his company tried to register the term OpenAI, everything came to light, and eventually the court took away the trademark from the Ravine character and gave it to Sam Altman, and again, the OpenAI as we know it, and your boy Ravine was, again, SOL at that point. So that's kind of a in-depth summary of what's going on. Like I said, I'm gonna pull up this article and really kind of go through things, because it's a number of takeaways that I think is important to note from this article, so that you guys don't find yourself in a similar situation. So shout out to Bloomberg. OpenAI trademark victory sets roadmap for avoiding IP missteps, and I completely agree with that article. So OpenAI Inc., which again, that's the OpenAI that we all know, recently defeated Open Artificial Intelligence and its founder Ravine in a trademark battle that reminded the tech world that timing isn't necessarily everything when it comes to prevailing intellectual property battles. So OpenAI, like I said, I'm gonna call OpenAI in this video the company that's owned by Sam Altman, and I'm gonna call Open Artificial Intelligence is kind of the company owned by Ravine. And like I said, as this paragraph highlights, this is an interesting case because typically it's really a first come, first serve. If you file your trademark application first, then you get your place in line. But in this case, OpenAI, that's owned by Sam Altman, he ultimately wound up with the trademark for the term OpenAI, although he was second in line for filing his trademark. We're going to see why was that the case and why the founder of Open Artificial Intelligence, Ravine, where was his missteps. So as the acceleration of the technological innovation speeds up, this case serves as a reminder to companies that despite the rapid technological advancements, they can't ignore existing intellectual property laws or skirt legal ethic lines try to defeat competitors. In other words, I see that paragraph is saying IP is still important and you need to kind of follow the rules when you're protecting your intellectual property. The court's decision provides a helpful framework for entrepreneurs seeking to protect their company names under trademark law, including a discussion of what constitutes proper use of a trademark. Ravine started working on Open Artificial Intelligence shortly before OpenAI was founded, aiming to create a tool to allow collaborators on a new AI developments. Ravine purchased the OpenAI domain. He purchased it in 2015, so 10 years ago. I'm interested in knowing what he purchased it for. I would imagine that mark, especially over the last 5 years, I should say, is worth way more than what he purchased it for. But he purchased it several months before OpenAI was founded. So OpenAI by Sam Altman was founded later in December of 2015. Ravine and Open Artificial Intelligence was founded March of 2015. So all this stuff kind of runs together. He didn't file a trademark application at that time. So Ravine did not file a trademark application. Let's see, Ravine. Yeah, when he purchased it back in March of 2015. One day after the well-known OpenAI was founded, Ravine applied to register OpenAI with the USPTO. So you catch that? He filed for the trademark of OpenAI once Sam Altman company was founded. Talking about gamesmanship. The USPTO rejected his application, however, because it was descriptive and he hadn't demonstrated use in commerce. Now, I do want to stop it for myself here really quickly. When you are filing a trademark application, it's different set of classes. And much like I'm not going to explain principal and supplemental registrar, I'm not going to kind of go through each level of class. I previously made a video. Go check out that video on the channel. But for the most part, I will say, hey, a generic mark and a descriptive mark cannot be, a descriptive mark cannot be trademarked at the beginning. Now, you can potentially trademark it later down the line once you get what is called secondary meaning. However, a descriptive mark cannot be trademarked at the beginning. Now, if you have a suggestive mark, an arbitrary mark, and a fanciful mark, those are distinctive and therefore can be trademarked at the beginning, but not a descriptive mark. Like I said, I made a video on the different forms of mark. So go check out that video, but I'm not going to break it down in detail here. Let's kind of pull back up the article here. So as time, there we go. So he couldn't trademark it at the beginning, at least on the principal registrar, because it was descriptive and he hadn't demonstrated use in commerce. In other words, when you file that specimen, that's showing that you're using a mark in commerce. So not only does a mark can't be descriptive at the beginning, you have to be able to show that you're using it in commerce. So in response to this rejection, Ravine filed a substitute specimen of an image of a home screen of his product hub, the mark registered on the supplemental registrar. Like I said at the beginning, he registered his mark on a supplemental registrar. One of the biggest differences between a supplemental registrar and a principal registrar is the mark is not considered to be distinctive at that time of registration. So, and again, he seemed like he filed a substitute specimen. And keep in mind that that substitute specimen ended up being huge. His substitute specimen was an image of the home screen of his product hub, whatever that means. I'm not sure what that means, but that was his specimen. As time passed, OpenAI continued to innovate and launch several successful products, including ChatGPT. OpenAI attempted to register its OpenAI mark with the USPTO, but was unable to do so due to the merely descriptive nature of the mark and Ravine's opposition to such registrar. So once OpenAI, that's owned by Sam Altman, started popping, he like, man, I'm going to register this thing. But the USPTO rejected his trademark application, number one, because they said his mark was merely descriptive, which again was similar to what they said when Ravine tried to register that mark. Then number two, it seems like Ravine and Open Artificial Intelligence opposed his registration. So those were the two things that were stopping Sam Altman and Sam Altman and OpenAI from registering the mark OpenAI. Following ChatGPT's success, so ChatGPT blew up. And now, given that success, now you have the secondary meaning. So as I told you guys before, hey, you cannot register a descriptive mark at the beginning because it's descriptive of the goods and services. However, once it gets that secondary meaning, in other words, once the public says OpenAI and they can identify the term OpenAI with your company, now it has acquired that requisite secondary meaning. Now that descriptive mark can be trademarked. So it seems like in OpenAI and Sam Altman's case, given a ChatGPT success, that ultimately raised the secondary meaning or gave him secondary meaning for his descriptive mark. And now it can be registered. That's pretty much what that paragraph is telling you. Hopefully you guys are paying attention to this. So it says, and following Ravine line similar. So it seems like based on ChatGPT's success, Ravine and Open Artificial Intelligence tried to pretty much copy off of Sam Altman and launch similar products. This prompted OpenAI to bring this lawsuit in 2023 to settle the parties' competitors' assertion of trademark rights. Most recently, OpenAI filed a motion for summary judgment. So this is still crazy because OpenAI is filing a lawsuit even though they really don't have a trademark. They're using OpenAI as a trademark, but they don't have it registered on a principal registrar or on a supplemental registrar. Yet they still sued Ravine and Open Artificial Intelligence for trademark infringement. And it seems like they filed a motion for summary judgment, which means that, hey, there's no dispute here. And the district court in California granted Sam Altman and OpenAI's motion for summary judgment. OpenAI also moved to cancel Ravine's registration on the supplemental registrar, alleging he knowingly intended to mislead the USPTO. So it seems like they're saying that the specimen that Ravine submitted was fraudulent. That's essentially what Sam Altman and OpenAI is saying. And it seems like Ravine argued that there was genuine disputes of material fact as to whether he intended to deceive the USPTO, further asserting the bizarre argument that attorneys regularly submit false information to the USPTO. The court granted, hey man, don't be looking. Hey, Ravine, don't come after the attorneys because you got caught with your hand in the cookie jar. This is what he said to Ravine's argument to the court is, hey, everybody the attorneys submit fraudulent information to the USPTO. That's a crazy argument. That's why the article said that's a bizarre argument to say, hey, everybody is doing it. He's not saying that, hey, I didn't do anything fraudulent. What he's saying is, hey, everybody does this, which clearly is not going to be a winning argument. And the court did not buy that argument and therefore granted summary judgment to OpenAI to cancellation claim. So essentially, Sam Altman and OpenAI was able to cancel Ravine's registration on the supplemental registrar. Let's move on here. Although it would seem obvious that all representation and filings with the USPTO must be accurate and truthful, it may be tempting for companies to falsify or even enhance specimens to demonstrate actual use in commerce and obtain or maintain a trademark registration. It may be enticing for companies to take shortcuts. However, this decision serves as an important reminder to companies that make false representations to the USPTO can lead to cancellation of a registration. Although such practices may result in short-term gains, they may also result in loss of the rights the company seeks to protect. In addition to the cancellation claim, both parties claim trademark infringement against the other. The court granted summary judgment to OpenAI on all claims. Ravine argued that as the first user of the mark, he couldn't be liable for trademark infringement. The court, however, pointed out that a first user's use of a mark isn't protected beyond its original line of use into an area occupied and intervener junior user who's established his own rights in the mark. So I think that's worth stopping for because that's important. So the USPTO was saying, hey, OpenAI, Sam Altman, even though they came after you, Ravine, and you're a mark that was registered on the supplemental registrar, number one, your specimen was fraudulent and therefore it shouldn't have been registered at the beginning. And then number two, your specimen gave you rights in this particular area. And Sam Altman and the OpenAI mark, they were using it in other areas that your mark did not cover. And therefore, You cannot say that they infringe your trademark by using it in areas that your registration did not cover, even though your registration was on the supplemental registrar. I mean, that's important. So hopefully you guys do understand that. Maybe you guys have to kind of go back and look at that again or reread that a couple of times to make sure you understanding what the court is saying. The court is saying, hey, number one, your stuff was fraudulent and you shouldn't have been given a trademark even on the supplemental registrar. But number two, and more importantly, your use of your mark isn't protected beyond its original line of use into an area occupied by an intervening junior user who established his own rights in the mark. So Sam Altman and his OpenAI mark and protection and his uses was in areas that you didn't have essentially rights in. So that's very important. So after OpenAI became well known and acquired secondary meaning, I was telling you guys that before, Ravine drifted into OpenAI's market segment. So this actually was the reverse. You went into his area after he blew up, after Sam Altman and OpenAI blew up and began offering similar products. The court decided that this amounted to trademark infringement. So the fact that you went into his area after he had trademark rights in it because it acquired secondary meaning, you infringed his trademark. That's crazy. Even though Ravine purchased the OpenAI domain name prior to the launch of the OpenAI, he was using the mark in some capacity prior to OpenAI. Those rights aren't without limit, and the subsequent copying of the OpenAI by using the mark for comparable goods or service was sufficient to amount to trademark infringement. So that's pretty much it. Hopefully you guys understood that. Like I said, this is an extremely important, not only article, but it's an extremely important, make sure you understanding what's coming on. And obviously this is applicable, being applied to obviously OpenAI and Sam Altman and ChatGPT and all that stuff, which has seen taking the world by storm these days. The principles illustrated in that court decision are extremely important, which I'll recap them here before I let you guys go. Number one, do not file fraudulent paperwork with the United States Patent and Trademark Office. And definitely don't do that and then say, as an argument, everybody does it. If you're filing specimens to the USPTO, those specimens have to be accurate information. Do not knowingly file false information, because even though it may kind of benefit you in the short term, as the article put, long term, when somebody challenges this stuff and it gets in front of a court and a judge, you can run a risk of losing your trademark. Then number two, understand that if you are filing a trademark and using a mark before someone else, which that other person would be considered a junior user, your mark and a protection may not extend into areas that are outside the scope of the specimen that you submitted. Seems like in this case, Ravine, his specimen was in one area, and then Sam Altman and OpenAI started using a mark in another area, which Ravine's mark did not cover. And therefore, even though Sam Altman and OpenAI was a junior user or used the mark after Ravine's protection did not cover Sam Altman, OpenAI's mark in those new areas. And that was even kind of, that was kind of further submitted by the fact that Ravine tried to submit similar products in that area that Sam Altman and OpenAI was in. So that kind of further shows you that, okay, he wasn't operating that area of OpenAI when he initially kind of submitted his specimen and submitted the mark and got it registered on a supplemental registrar. So that's pretty much, man, my 2 cents for this one. Like I said, this was a little longer than my typically videos as relates to these current events, but I thought this was extremely important because I want you guys to be successful. I want you guys to protect the intellectual property, but knowing these nuances of how this stuff can come back and bite you is very important, especially when you're kind of filing these trademarks and protecting this stuff. Because you can think that you filed a trademark, you getting protected in everything under the sun, but if you're not in those areas and those specimens are not provided to show that you was in those areas, you're most likely are probably not going to get protection in the area. And if somebody comes on after you, even though your mark may be registered, then you can be SOL. So hopefully you guys enjoyed this one. Hopefully you guys understood this one. Please leave your comments in the comment section to let me know your guys' thoughts and let me know whether or not you understood it. And yeah, hit that like button for the YouTube algorithm if you enjoyed it. Hit that subscribe button to be a part of the IP community. I'll catch you guys on the next one. Peace.